Now, this particular manifesto, which Milord is taken as a Magna Carta virtually, and that's what Milord Justice Anand says in his book on Constitution, was then accepted in the Constitution, and whatever people said ultimately in the manifesto, most of it, Milord, was included in the Constitution. This is known as, Milord, the new Kashmir, they call this manifesto. Now, the importance is this, Milord, that the sovereignty rests with the people and they express, Milord, their sovereignty in a particular way. This is what they want. This is kind of democratic setup they want. Now, this sovereignty was, Milord, accepted when the Constituent Assembly was sitting and was translated, Milord, ultimately into the Constitution of Jammu and Kashmir. So there are two things, Milord, which emanate from it. Number one is that the sovereignty which rests with the people, and they, Milord, expressed it, and that expression was translated ultimately, Milord, into the Constitution which they gave to unto themselves. That's number one. Second is, Milord, when there is a written Constitution, then that written Constitution is supreme. Now, Lordships, Milord, noted that judgment in Article 143, that privilege case, Milord. I'll just give the citation and the para number, which says, Milord, that ultimately in a democratic country having written constitution, it is the constitution which is supreme and sovereign. That is, Milord, 1965, 1 SCR 414, and it is in volume 17, PDF. It starts at 337, at 357, para 40. Note that in my submissions because it has not come. My Lord, the second judgment which I just wanted to draw your Lordship's attention is my Lord Bhumi's case, which has been cited before Lordships. It is para.
So what's the, if you can conceptualize it?
The conception, my Lord, that's what I'm saying. I'm saying that this, my Lord, the entire idea, people said they want to have a democratic setup. And therefore they came together, gave themselves, my Lord, a manifesto. Manifesto was translation of their wishes or desires, that it should be in a particular way. That, my Lord, was given to Maharaja at that particular point of time, that please accept it because we want this monarchy to end, we want a democracy to come. So this expression, my Lord, which was given in the manifesto, was translated ultimately because, as I said, it was a Magna Carta, and in the discussion also we find
that the fact is in your
Lordship,
submission.
so therefore the idea is
that Parikh, we look at your submission.
I know Lordship said formulated. So it's, my Lord, ultimately the sovereignty which rests in the people, ultimately transferred, my Lord, in the Constitution. As I said, the Constitution is supreme and sovereign. My Lord, that's the idea. And I, my Lord, refer to the two paragraphs. One is, my Lord, in the 1965 judgment, which is para 40, and para 102 and 103. So Justice Sawant's, my Lord, view in Bhumai, and if your Lordships permit me, I'll read only para 103, and this particular part will end. In this connection, may I give, my Lord, your Lordship, the PDF?
No, we got it, yes.
Yes. This will be PDF 171, 172 of Case Law, Volume 2. 272? 271, 272. Now 102. Now 102, my Lord. 271.
Yes.
Now the Lordships may skip, my lord, the earlier para, last 3-4 lines. It is true to say that democracy, people are sovereign. All powers belong primarily to people. The retention of such power by the people and the
That's true. These are well.
Lordships.
We've read them.
Now, my lord, 103 is how the states are formed on the basis of linguistic, ethnic, and
That's
other
all,
things,
yes.
and that cannot be disturbed.
Yes.
Lordships were noted. That's enough, my lord, for me. Now, the only thing is, my lord, that in the book, Justice Anand, my lord, says that as far as the sovereignty is concerned and autonomy, they are, my lord, interchangeable terms. That what you call sovereignty is autonomy. Now, that is, my lord, something which is important when we say whether there is autonomy. Autonomy in the form of sovereignty, sovereignty with the people, and ultimately in the Constitution of Jammu and Kashmir. Now, my lord, with regard to the interpretation of 370, Lordships have read it number of times. I just wish to point out, my lord, two things. One is, my lord, when we look at 371B and, my lord, 370D first proviso. These, my lord, two provisions, they talk about the consultation. Rest is concurrence. So my argument is, my lord, as far as the concurrence is concerned because the Constituent Assembly doesn't exist. And I must point out, my lord, how the Constituent Assembly of Jammu and Kashmir, because that has not been pointed out, how it was dissolved. There was a resolution, and pursuant to the resolution, it was dissolved. So therefore, my lord, those parts are concerned. The provisions, my lord, in terms of the 1954 presidential order, which has been issued, my lord, I know lordships are probably, if I'm repeating something, then 1954 presidential order, which is there. If you look at the 6 presidential orders which have been issued, the first one is, my lord, consultation. There are other 3 consultation. One is, my lord, CO 44, which is, my lord, under 373, where, my lord, the Constituent Assembly's prior recommendation was taken because they changed the explanation there from, my lord, Maharaja to Sadr-e Riyasat. So that is, my lord, one thing which shows that ultimately you require prior recommendation of the Constituent Assembly. The only provision is 1954, which talks about the concurrence. My submission is, my lord, that the concurrence ultimately comes to an end because the Constituent Assembly is not there. But the question arises, my lord, which a lordship may put to me, what about the presidential orders which have been issued subsequently? The only answer, my lord, which I think can be given is that all the subsequent presidential orders which have been issued are either some changes, some amendments in the 1954 presidential order. They are not, my lord, because the areas were carved where the union will legislate, and the areas, my lord, where the Kashmir, Jammu and Kashmir constitution will prevail. Therefore, my lord, all those things which have been issued can be justified only on this basis that these presidential orders, because 1954 presidential order was issued after, my lord, the concurrence of the Constituent Assembly or approval of the Constituent Assembly of Jammu and Kashmir. Therefore, the subsequent presidential orders which are issued were under the presumption that the Constituent Assembly's approval already exists as far as the presidential. You know, this is one way to look at it, because when I tried to find out, I couldn't get, my lord, any answer, because if the Constituent Assembly comes to an end, naturally the entire, my lord, there is no Constituent Assembly, therefore there can't be any concurrence in that sense, which is provided, my lord, under 370. I have formulated, my lord, 370. I just read, my lord, 2 formulations. 370, I am reading that, my lord. Provided the constitutional mechanism by which the instrument of accession was integrated into the Constitution of India. Recognized, semicolon, recognized areas where the Constitution of India will operate, and by respecting will of the people, carved out the areas where the Constitution they wish to give unto themselves will prevail. Second is, 370 is temporary in the sense that it contained the principles which would govern the formation of Indian Constitution as applicable to J&K as well as the Constitution of J&K. Once that was achieved, the aim and object of 370 was fulfilled. Seeing each other, meeting each other was converted into a relationship on mutually decided terms. It is this relationship which is permanent. This relationship could not be unilaterally altered. It is like a constitutional promise embedded in will of the people. With the dissolution of Constituent Assembly of J&K achieving its purpose of giving birth to the Constitution, the temporary provision achieved the permanent result. The other significant permanent feature being that people of J&K accepted J&K with all its territorial limits to be an integral part of India for all times to come. Now, my lord, there are three documents, my lord, on the basis of which the interpretation of 370 is possible. One is, my lord, the Constituent Assembly debates in India, the Constituent Assembly debates of J&K, and the judgment in Premnath Call. Now, from all these three documents, my lord, two situations emerge. One is that the Constituent Assembly will have a final say. All, my lord, the debates as well as debate in Jammu and Kashmir and, my lord, the Premnath Call judgment says so. That number one, Constituent Assembly will have a final say. And number two is, relationship will be finally determined by J&K Constituent Assembly. These are the two factors which are common, my lord, in the entire thing. I just wish, my lord, because the Mr. Gopal Subramaniam had read, my lord, the debates in Jammu and Kashmir Constituent Assembly, but I just wish to draw your lordship's attention to my submissions, 504. Just, my lord, look at 512. These are my submissions, my lord, which is in volume 1 of the submissions, starts from 504. Just kindly come to 512.
Yes.
And then, my lord, lordship may skip. This is, my lord, what Sheikh Mohammed Abdullah makes a statement on 370. The entire paragraph is that. Lordship may skip that and come to, my lord, 514. Just above para 26. The Constitution of Indian Union therefore clearly envisaged the convening of a Constituent Assembly for Jammu and Kashmir state, which would be finally competent to determine ultimate position of the state in respect of the sphere of its succession, which would be incorporated as in the shape of permanent provisions in the Constitution. This briefly is the position which Constitution of India has accorded towards it. Now, this was, my lord, the same thing which you find in the debates, my lord, Gopal Swami Iyengar. He says the same thing we find, my lord, in the judgment of call. And this is what. So there was, my lord, ad item as to what should be the shape and what should govern the relationship between, my lord, Jammu and Kashmir and India. Now, my lord, 26 is, which has not been shown to your lordships, how ultimately it was dissolved, the Constituent Assembly of Jammu and Kashmir. Now, my lord, this is the statement which was made by Mir Qasim. He said, my lord, whereas the Constituent Assembly came into being for framing the constitution for the state, whereas the Constituent Assembly has enacted and adopted the Constitution for the state, now therefore this Assembly resolves shall stand dissolved on 26th day of January 1957, which is the date of commencement of the Constitution. Sir, I would like to make a brief submission with regard to this resolution. The resolution aims at dissolving the Constituent Assembly by passing and adopting the Constitution, which will come into force on 26 January. The Assembly has done its primary and main function, and it is but natural that it would stand dissolved. Legally, it could not have been dissolved by any authority because people elected this Assembly for a specific object. Now, the object having been achieved, it is reasonable to resolve it by way of a resolution. Hence the resolution. This Assembly is not capable of protecting the Constitution. It had only the mandate of framing and enacting the Constitution for the state and nothing more. Now we can skip the entire thing, my lord. And finally, on the next page, the last 4 or 5 lines, Mr. President, the question is whether the Constituent Assembly came into being for framing the Constitution of the state, whereas the Constituent Assembly has enacted, they adopted the Constitution. Now, therefore, this Assembly resolves it should stand dissolved on 26 January, which is the date of commencement of the Constitution. And we close the business. And then, my lord, after this cross is, my lord, the proceedings on 26th of January 1957. Mr. President, today this historic session ends. With this, the Constituent Assembly is dissolved according to the resolution passed on 17th November 1956. Clock struck 12 p.m. and Constituent Assembly was dissolved by the President according to the resolution adopted on 17th November. I thought I must draw your lordship's attention to this important part, how it was dissolved. Now, my lord, as I have read, my lord, on 370, I am not going into, my lord, the Sampath Prakash and other arguments which I am skipping because all that has been argued. Now, lordships may only look at one part, 2 parts actually. The presidential order, my lord, which was passed on in 1954, had expressly, my lord, excluded Articles 356, 357, and 360. Kindly look at, my lord, lordships have seen that, aware of that. That is volume 3, page 18. Now, these were expressly excluded, and because they were excluded, it was with the understanding that as far as there is a breakdown of constitutional machinery in Jammu and Kashmir, then ultimately it will be taken care of under the Constitution of Jammu and Kashmir, and they brought in Section 92 for that particular purpose. Now, thereafter, my lord, and this was with the concurrence, which, my lord, my argument, if it is accepted, then after that, no change was possible because 92 had already come into operation, which took care of the entire situation. Now, 356 was brought in by virtue of CO 71 in 1965. Now, lordships will mark it. This is page 37 if you lordships want to see volume 3. Now, 357 was not adopted. 357 was not brought into. It is only 356. So one question which arises is, we have to, my lord, question that what is the implication ultimately of 357 not being there? I hope I am clear, my lord. If your lordships want to note down the pages, I can.
Yes.
No. My lord, that 54 presidential order, just show me that. Yes, what I am trying to, my lord, point out is this, that the Constituent Assembly of Jammu and Kashmir,
At that time,
finally, when the
356
situation,
was not, 356 was not there. Subsequently, 356 has been made applicable.
no, my lord, what I am trying to say is, I can show the debates when 92 was inserted, section 92. What were the debates, my lord, in the Constituent Assembly of Jammu and Kashmir? What I am trying to show is the Constituent Assembly of Jammu and Kashmir ultimately approved that 356, 357, 360 will not be there. And therefore, my lord, 92 came into being. So 92 provided for the situation because 92, equivalent of 92 doesn't exist for as far as other states are concerned. Thereafter, my lord, the changes were made, and in 1965, 356 was inserted, brought in. Said wherever constitution is mentioned, you read it as Constitution of Jammu and Kashmir. 357 was not brought in. Now, if you look, my lord, read 356, it says that you give parliament ultimately or to the president. Under 357 alone, that the orders can be passed or law can be made. Kindly look at 357, my lord. This will also have a bearing on, my lord, section 3, but I am not going to those parts. Now, 357 says, whereby a proclamation issued under clause 1 of Article 356, it has been declared that power of the legislature of the state shall be exercisable by or under the authority of parliament. It shall be competent for the parliament to confer on president the power of legislature to make laws, authorize the president to delegate, subject to such conditions as he may think fit, for parliament or the president in whom such powers are vested to make laws conferring powers for imposing duties. I'll take your lordships, my lord, through the governor's proclamation 92.
Article 357 has not been made applicable.
It has not been made applicable.
And therefore, though Parliament can assume to itself the power of the state legislature to enact laws,
Yes,
you cannot further delegate it to the president.
correct. You cannot do that. That's not my argument. And kindly, my lord, see the proclamation which was issued on 20th of June 2018. Let's look at that, my lord. Proclamation, my lord, is at volume 3, page 85. I am saying, my lord, that there is a machinery which existed to take care of the constitutional breakdown. And I am quoting again Justice Anand's book because he says, relying upon number of judgments which are given by, my lord, the Jammu and Kashmir High Court, whether it is, we can reconcile both. And the argument is, yes, we can reconcile. But the question is, ultimately 92 acts in a particular sphere and 356 acts in a different sphere altogether. You can reconcile, it can exist. But the question is, they operate in different fields. And once you exercise power under 92, and you say we are dissolving, and look at, my lord, this particular proclamation, which is, my lord, at page 85. Just look at it, my lord, in 92. And I'm asking myself why 356 was not issued initially. It could have been done. Why they resorted to 92? An answer will also come, my lord. Answer is because after the proclamation, on the next date, he dissolves, my lord, the assembly by resorting to section 53 2B, which could not have been done without the aid and advice of the council of ministers. Why it was done, my lord? Because it is dissolved, and then you take over ultimately. Now, proclamation, my lord, says powers conferred by 92, enabling me on that behalf with the concurrence of the. Now, one important factor I must mention. I'm so sorry, I have to hurry up, my lord, otherwise necessary for me to show, but because lordships are aware, I'm going on that basis. Section 92 says, my lord, concurrence of the president. So naturally, when this proclamation was issued, there was proclamation, it says so. There is a proclamation of President of India. Now he gives, my lord, the concurrence to the proclamation which was issued, the president. And after that, my lord, certain provisions are suspended. He says any reference to state constitution or acts or made by the legislature shall be construed as including reference or acts made by me. That is on page, my lord, para 5. In exercise of powers of legislature of the state under the proclamation made under such and such. So assumes, my lord, on that date itself, the powers to make the laws. Now, my lord, look at this one and 357. How you reconcile both the things. And next day, my lord, he says power vested upon me under 92(1), exercise of powers under 53(2)(b) of the Constitution, Jammu, I hereby dissolve the Legislative Assembly. Now, 350, section 53(2)(b), if we read, my lord, section, I think 35, that this can be done. 92 you can exercise without the aid and advice of the Council of Ministers, but 53 you cannot do, which is necessary. So he does, my lord, a thing which is absolutely unconstitutional act. It was impermissible to do it. My argument here is, if your lordships, my lord, I can give certain, there's a discussion by Justice Anand in his book about how these two provisions can work in Kashmir. That is volume 17, PDF, my lord, at 143, 144. My lord, my submission is, in this situation, it was not permissible for the President, my lord, to invoke the powers under 356 because under 92, and 92 is something which was approved ultimately by the Constitution of India and also the Constitution of Jammu and Kashmir. It's a malafide, excess of power and a fraud, which, my lord, I don't want to go into the judgments. Now, my lord, my probably last, I must say, argument is with regard to CO 272 and 273. Just kindly have a look at, and the argument will be very brief. Kindly look at, my lord, 272 at page, I think, PDF 101. Lordship had put a question to Mr. Sibal. This is 5th of August 2019. And 6th, my lord, is the final order which has been issued, CO 273. I must say, my lord, before I go to 272, is that 273 assumes, my lord, the fact that the prior recommendation of Constituent Assembly is necessary. If we understand that way, my lord, then kindly look at it. It means if you want to make any change in 370 as such, which we draw, my lord, from CO 44, which I pointed out, where you change the explanation. That's the only thing, my lord, which the Constituent Assembly approved. Now, here, my lord, what they do is that through the interpretation clause provision, they, my lord, indirectly change 370 itself. Kindly look at, my lord, this one. To 367 shall be added the following clauses. Lordships may skip A. A says construed as references to such and such. B is references to person for the time being recognized by President recommendation of Assembly. Sadr Riyasat, acting on advice of Council of Minister of State for the time being in office, shall be construed as references to Jammu and Kashmir. Now, exactly the same words which are used in the explanation. So they are changing, my lord, the explanation without the prior recommendation of Constituent Assembly. And look at, my lord, below that. In proviso D, 3 of 370, expression Constituent Assembly of State 2 shall be read as Legislative Assembly of the State. Now, my lord, I ask myself that how this is possible that you can change 370 as such by virtue of the interpretation when you recognize in the very next order which was issued that Constituent Assembly's prior recommendation is necessary. So this interpretation, my lordships are asked, why this interpretation? Without this interpretation also something was possible. This interpretation was resorted to because they wanted to So the exercise ultimately done by them by CO273 is something which is constitutional in nature. That is to say that they have done this thing after prior recommendation of the Constituent Assembly. So how they may not achieved it, they changed 370 to the interpretation clause. Absolutely may not unconstitutional act. And after doing this, I hope I am clear, Miller. After doing this, then may not the final order is given. What it says, CO 273. In exercise of powers conferred by clause 3 of 370, read with clause 1 of 370 of the Constitution, the President, on recommendation of Parliament. So, my lord, the recommendation of the Constituent Assembly after that was substituted by recommendation of Parliament. Is pleased to declare as from the such and such all clauses of the 370 shall cease to operate. So what they do is they know without Constituent Assembly they cannot do. Constituent Assembly is not there. They bring in through the interpretation indirectly. And my submission is what you cannot do directly, you cannot do indirectly. That's again a fraud on the Constitution. God should have followed me, Lord.
This argument has been raised.
It was, I'm so sorry, because I think I was attending all the, in this, because Rochester put a question to Mr. Sibal, what's the meaning of this interpretation clause? Why they resorted to interpretation? They resorted to interpretation because they could not have done directly with 370. Therefore, they resorted to, and after making change, came out, my lord, with this one, on the recommendation of Parliament. Now, other question, which is a prior recommendation. According to 373, it is prior recommendation of Constituent Assembly. It has to be prior recommendation. Now, kindly look at, on 5th of August, this notification is issued. How, my lord, next day, a prior recommendation of Parliament was sought. On the face of it, my lord, it looks obvious that this is something, my lord, which is not permissible. The entire exercise, my lord, shows that it is mala fide in nature. So therefore, my lord, this goes, 272 goes, the other, my lord, proclamations which are issued, they also go.
Thank you, Mr. Parikh. Thank you.
My lord, it becomes very difficult sometimes because I know, because you read a lot, chip by chip, my lord, things are removed. Few chips remain, my lord, then you have to sustain yourself on those chips. So probably I do not have done whatever.
Thank you, Mr. Parikh. Mr. Sen.
More than 7-8 minutes.
Yes.
Fast as possible. Just 3 points I want to highlight. Proposition being a more restrictive and strict approach in interpreting Article 370 for 3 reasons. I'm taking the broader view because the nuts and bolts have been gone into. The first reason is historical. The second is jurisprudential. And the third is in terms of the constitutional ethos. The historical part, my lord, which I'd like to emphasize for a more restricted and strict interpretation is that the region consisted of a Muslim majority. And the population, my lords, had a choice between either going into Pakistan or into India, either being a majority in Pakistan or choosing to take a minority status in India. My lords, it chose the latter. And my lords, although the historical part has been dealt with about the signing of the instrument of accession, just a few pages I'll highlight to show how it was Sheikh Abdullah who represented and who had a hold over the population at that time, who was responsible for this transition to India. And therefore, my lords, one of the important points which I'd like to make is that if there is a choice, a conscious choice made to remain a minority in a region in the backdrop of the horrific violence of partition, my lords, when there's a constitutional promise in the nature of Article 370, it should be strictly construed. That's my first point. And my lords, in regard to that, my lords, may I just point out 2 or 3 pages, VP Menon's book on the integration of the nation state. I'll just point out the pages so that I don't take time. My lords, page at volume 15, PDF page 1258, where it just mentions that Sheikh Abdullah rose to power to fight for the rights of the Muslim community. By 1939, the body had shed its communal complexion and changed its name to National Conference. He had a considerable hold over the people of the state. That is VP Menon's book at page 1258. Then, my lords, may see page 1259 PDF, the Maharaja was assured by Lord Mountbatten that if he acceded to Pakistan, India would not take it amiss and that it had a firm assurance of this from Sardar Patel himself. Lord Mountbatten went on to say that in view of the composition of the population, it was important to ascertain the wishes of the people. This is PDF page 1259, volume 15. The situation for the Maharaja was not easy. This is again Menon pointing out. If he acceded to Pakistan, the non-Muslims of Jammu and Ladakh, as well as considerable section of Muslims led by National Conference, would have resented such an action. That is page 1259, PDF page 1259, volume 15. The government of India had no territorial ambition in Kashmir. If the raid by the tribes had not taken place, government of India would have left Kashmir alone. That is at page 1271, PDF, volume 15. The tribal invasion was not a spontaneous affair engineered by Pakistan. That is at page 1271, volume 15. The accession was legally made by the Maharaja of Kashmir, and this is important. And the step was taken with the advice of Sheikh Abdullah. That is PDF page 61, volume 20. This is A.G. Noorani's book, my lords. This is not, up to now I was stating Mr. Menon's book. This is A.G. Noorani. And then my lords may see, on 27/10/1947, in reply to the request for accession by the Maharaja, the Governor General of India, Mountbatten, clearly stated that the issue of accession should be decided in accordance with the wishes of the people as soon as law and order had been restored in Kashmir. This is PDF page 59, volume 20. In the context of these historical facts, both Nehru and Sardar Patel were of the clear view that Jammu and Kashmir should decide their own consequences. See letter of Jawaharlal Nehru dated 18th of March, 1949, PDF page 67, volume 20. This is again A.G. Noorani's book. It is in this context, my lord, that 370 emerges. So, my lords, my first submission is this, in this context, that when there is a conscious choice made in this manner, my lords, all the more reason why it should be taken strictly. And in this context, may I just point out S.R. Bommai at page 218, PDF page 218, volume 2, which says that federalism is not seen merely as a matter of administrative convenience, but one of the principal outcomes of our own historical process and a recognition of ground reality. And my lord, this leads to what is called asymmetric federalism, my lords, which has been extensively dealt with by my lords in the NCT judgment 2. It is also, my lords, in fact, one of the first persons who coined the term asymmetric federalism in the Indian context was Professor Balbir Arora from Sorbonne, and he was also the professor for political science in JNU. And his book, my lord, which is at page 242 to 243, PDF page, volume 17 of the document compilation, where he talks about the nature of asymmetric federalism, which was there, which is to take into account different regional aspirations, and it has a remarkable degree of flexibility and pragmatism. It is a calibrated institutional response to the diversity of constitutional unit permeating both de facto and de jure variation. My lord, thereafter, my lords, may I just point out the above fact that it is an anti-majoritarian or a protection against majoritarian that asymmetric federalism provides. And in that context, my lords, our constitution is also a anti-majoritarian in many ways, my lords. There are lots of judgments which have dealt with it. I put it at E.3 of my written statement at page 500. That is E.3 of my written statement. Then, my lords, Keshavanand Bharti case at para 208, PDF page 151, volume 15, where I point out that where it is emphasized that in case there is a it quotes, my lord, the case, and I'll just quote it. I may mention that the Judicial Committee, while interpreting British North America Act 1867, had also kept in mind the preservation of the rights of minorities. For they say in the regulation and control of aeronautics in Canada, the British North America Act embodies a compromise under which the original provinces agreed to federate. It is important to keep in mind that the preservation of the rights of minorities was the conditions on which such minorities entered into the federation and the foundation upon which the whole structure was subsequently erected. The process of interpretation as the years go on ought not to be allowed to dim or whittle down the provisions of the original contract upon which the federation was founded, nor is it legitimate that any judicial construction should impose a new and different contract. This is echoed in Jindal Steel case at 2017 12 SCC 1, that is PDF page 219 to 220, where it is very clearly pointed out, again, it reiterates Keshavnan Bharti, that the original terms should not be whittled down. And so, my lords, the argument that so-called hollowing out of the Article 370 through various orders which have taken place. Already Mr. Nafe has argued that there was no hollowing out, the core remained. But assume that there was a hollowing out which takes place. It is a political act. And my lords, has been very clear in this entire proceedings that we are interpreting the Constitution. So if because of a political act, there is a so-called hollowing out, which is without prejudice to that argument, I do not accept that it is. But if there is such is the case, even then that should not affect the interpretation of the provisions of Article 370. Then, my lords, Podwal case again highlights the aspect of asymmetric federalism, which I will not go into. My lords, the second point, briefly, what are the limits, my lords, if you're looking at the broad approach, what are the limits by which we will determine what are the limits of a constitutionally vested power? And my lords, the answer is the analogy of Mill's famous thing on liberty, that your liberty ends where the other man's nose begins. So the moment there is a fundamental constitutional principle which is there, which is getting affected, the limit must be there. And my lords, in that context, the NCT judgment case, there are 2 pages I'll just point out, PDF page 92 at para 108, volume 5, and PDF page 35 at para 40, volume 14. My lords, also there is the Miller case, that is at PDF page 324 of volume 5, recent Miller case in the UK, in the context of proroguing of the House, where again this concept is put forward. So it's an international constitutional concept, which is also equally applicable here. It has been reiterated by various judgments in India. My lords, I would also urge that if we are talking about minority rights, if we are talking about anti-majoritarian or protection against majoritarian, well, there is the LGBTQ plus judgments, etc., which are coming. There is a evolution which is taking place. With respect, my lords, this kind, if one were to do away with this thing which involves historically a religious minority, not that they are necessarily expecting, if that is there, my lords, it will be a regressive step. And my lords, in line with what is happening, in which the evolution is taking place, more and more inclusiveness is there, it should not be there. I'd like to finally end, my lords, I won't take more time. I'd like to end by pointing out 1 or 2 quick points. One is, my lords, in our rejoinder at page 88, the Niti Aayog report is there. Now, my lords, there is no material which has been brought on why 356 was imposed. My lords, that has always all been argued. But the material of the government which is already there on record, it says in peace, security, effective governance based on rule of law and upholding principles of equality, Jammu and Kashmir rises above a number of states. And my lord, that I've put at page 88 at volume 13 of the Niti Aayog report, page 282 of volume 13 at page 286 and page 285. This is prior to abrogation. So my lords, this further kind of deepens the mystery. And of course, there are statements made by ex-constitutional authorities, not of much relevance now that he's not holding a constitutional post, but how it was exercised. But when this was the case, if Kashmir was a leader, it's used as a leader in these areas, where was the need for a 356? My lords, finally, one last anomaly which my learned friend had also pointed out, and that is, I'll just point out that in volume 3. Sorry, my lord, just a minute, just on the reorganization. I'm sorry. Yes. My lord, we come to section 57. My lord, it's the botched up kind of situation which is arising now with this. Of course, the Reorganization Act is consequential, I understand, but still, my lord, I may just point this out. 57 at PDF page 126, volume 3. My lord, it says, notwithstanding anything to the contrary contained in any law, document, judgment, ordinance, rule, regulation, or notification on and from the appointed date, the Legislative Council of the existing state of Jammu and Kashmir shall stand abolished. On abolition of Legislative Council, every member shall cease to be, etc. So it abolishes the Legislative Council. Now, my lords, what is peculiar is, just before this, the CO 272 is passed. CO 272 applies all the provisions of the Constitution. When you're talking about abolishing the Legislative Council, then it has to be as per section 169 of the Constitution of India, which is already stands applied on pursuant to CO 272. Once that is applied, then my lord, what happens? It can't be done away by way of this act. So we've already challenged the validity of this act, but my lord, this is like a Trishanku legislative council, which has not been abolished by any proper procedure which is prescribed by law. So my lord, that was the point, and there was one more. 73, my lords, is that, my lords, clause which has come even by way of amendment in the context of the Delhi government also, that if the president on receipt of a lieutenant governor, my lords, the same powers as 356, but no time limit provided. I'm very grateful, my lords, and I'm extremely grateful that my lords had this the technology which enabled us even many times, even while we were not present in court, we could keep in touch with the
Thank you, Mr.
deeply obliged.
Yes, Mr. Ramakrishnan.
One of the major political parties, and was heading the government at the time of governor's rule. And I have held office. I've formed the government twice before. I was a single major party, and I'm therefore, I would venture to suggest, much more representative of legislative will than that ersatz and duplicitous reference in CO 272 to the Legislative Assembly. I also represent writ petitioners in writ petition 1099, where Mr. Ramachandran was appearing, petitioners 3, 4, and 5. As far as I'm concerned, I appear for PDP. I don't
Who are
know
you?
what this is.
Who are you?
Who are you?
This writ petition 1099 was initially filed by 6 people. Then 2 of them withdrew, Dr. Shah Faisal, and then
I don't know what he's talking about.
when the writ petitioner number 1, who is Mr. Javed Bhatt. Javed Bhatt, when he engaged my learned friend, then the understanding of the senior counsel Raja Ramachandran would be arguing the matter. When he came to know that he has withdrawn from the matter, then he contacted a senior lawyer from Kashmir, Mr. Muzaffar Hussain Beg, who in fact...
I didn't know anything of this. I'm sorry. Let me represent PDP, the impleadment application. My lords will hear him whenever it's done.
We are not PDP.
Yes, I'm arguing for PDP now. My lords will hear me.
That's an intervener application, but the mandate petition, Farooq Bhatt is the petitioner number 1. When he engaged them, then the understanding was that Mr. Raja Ramachandran would be arguing the matter. When he withdrew from the case, then Javed Bhatt, petitioner number 1, he approached Mr. Muzaffar Hussain Beg. So we have filed the Muqaddimah that perhaps not has been placed on the board because of some timeline issues.
May I clarify?
That's what petitioner number 1 in writ petition number 1099, Mr. Muzaffar Hussain Beg would be arguing, of course, with the permission of my lords.
See, ordinarily there's no difficulty, but normally for all of the entire group of petitioners in a petition, you presume that they are sailing together. Therefore, one lawyer would appear for all the petitioners. For different respondents, different lawyers can appear. But for people who join together in a petition,
May I?
if there is some conflict within the petitioner, somebody has to get transposed or file another proceeding.
That conflict arose because of the wrath of Mr. Raja Ramachandran only.
May I make a clarification, Your Lordship?
Just for factual clarity, writ petition 1099 was filed by how many people?
By initial. May I?
Just one second. He's in charge. 1 second. Yeah.
I instructed in the matter, Your Lordship. There were initially 7 people.
Yeah.
Of which Dr. Shah Faisal and Ms. Shaila Rashid subsequently withdrawn. Mr. Ramchandran, in fact, argued their applications for withdrawal, and this was allowed by this court.
So we're left with 5.
There were 5. There was one Mr. Javed Ahmed Bhatt. His was petitioner number 1, who became the petitioner number 1 after Dr. Shah Faisal's withdrawal. So last evening, I received a request saying that there has to be a way in which we had another arguing counsel with the team. And this was because this was contrary to the express orders of the court, where it had said that all the petitioners' arguments had to be wrapped up today, and that a certain list was had. So and therefore I deemed it unreasonable to accede to that request at that time. And I had indicated that they are free to pursue their remedies, whatever they have. And they had therefore requested no objection, on which I had a separate, very detailed release covenants that I had in fact received from the petitioner, where in the detailed release covenants, he had covenanted that these hearings would not be interrupted, and after the hearing plan is over, if anything, with the permission of the court, he may take that is because as also the nodal council, we owe duty to the court that the.
Just 1 second, 1 second. Jadara mic band karo.
I don't want to appear for anybody in this writ petition. I will just appear for PDP. Yes, I don't want to appear for him. Uncouth to interrupt like.
In the petition which you are arguing, it is 1099. You are the first counsel to argue, right?
Yes, because Mr. Ramachandran requested me.
Right, right. In the last 3 weeks, you are the first person who is arguing this matter.
Correct. Until yesterday, I thought I was arguing for all the petitioners. And but I'm happy to just, please keep quiet. I'm arguing for PDP definitely.
Yes.
And let me argue for them. If my friend who he represents in that writ petition, I don't.
Now, Mr. Counsel, what you are suggesting is that Mr. Muzaffar Hussain Beg will appear for Mr. Javed Bhatt.
Yes, ma'am.
Now, you see, there's only one difficulty. See, we want to be fair. We don't want to shut out any voice. It's our duty to give a fair hearing to all perspectives. At the same time, you're also conscious as a member of the bar that in a petition, when a group of petitioners have come together, one lawyer appears for all the petitioners. There may be a little conflict or diverging interest between respondents, and therefore respondents are entitled to have separate representation. But at the same time, we are more than willing to hear Mr. Beg's perspective. The way to do it is then Mr. Javed Bhatt will perhaps have to withdraw from that petition 1099, and we'll permit Mr. Beg to make a brief representation as an intervener. We can do that. Ultimately, it's a question of yours of being heard by the Supreme Court, isn't it?
So of that. And she has very gracious.
So, Ms.
She has very gracious
Ramkrishnan,
that she would be representing PDP only.
Ms. Ramkrishnan, now the remaining 5 petitioners in 1099, who are those 5 petitioners? Is PDP party in that? Just 1 second.
PDP is an impleadment application. She is an impleader. Because she was in jail. She was in imprisonment when all these petitions were.
Her application is for impleadment.
Yes.
As a petitioner.
Yes.
But the others have to agree to her impleadment.
They have agreed. They have no objection.
Not impleadment, not for as petitioner, my lord. She wants to be impleaded.
Correct.
Who represents the other 4? One of them, this is a new development, but.
Just 1 second. Who's for the other 4 now? Or the other 5? Because actually there are 5 now left.
Shah Faisal withdrew.
And likewise, Ms. Sheila Afridi. Now, who's appearing for the remaining 5? Ms. Ramkrishnan, are you appearing? Forget Javed Bhatt's case for a moment. We'll say the remaining 4. Apart from appearing for the PDP, are you representing the 4 as well?
I was given to understand that until this minute.
But even at this minute, he is
I
representing.
represent it. If,
So we take it apart from the intervener, which is the PDP, you are appearing for the remaining 4 and you have instructions to appear for them by the advocate on record. All right. Now, insofar as Mr. Javed Bhatt is concerned, what we'll do is we'll complete the submissions of Ms. Nitya Ramakrishnan. Rest assured that we will give let's see how things progress. All right, we got the point now. Yes, Mr. Ramakrishnan.
I'll try and speak in bullet
But then
points.
only one thing. Do we take it that you, Mr. Javed Bhatt, seeks to withdraw from this petition so as to allow him a separate intervention?
No, he is not withdrawing as a petitioner.
But then if he is not withdrawing as a petitioner, we are trying to create some space for you. If he is not withdrawing as a petitioner, then the advocate on record will appear for him. How can you have a different counsel appearing?
Because he has obtained an NOC, and the reason as a.
When did he obtain
When did you obtain the NOC?
Very respectfully, I submit.
When did you obtain a NOC? Please tell us.
Yes, my lord. When-
You can't do
Middle
that.
of the matter on the last date of hearing, you obtain a NOC, then you say, now I want to appear for that one individual petitioner. He will continue to be the petitioner, while 4 others or 5 others are represented by another council. Because background or no background, we are not.
This we will not
background
permit.
much earlier.
In any case, one thing is very clear, even in a normal civil appeal, we will not permit people to withdraw in the course of a submission. And not when a matter has gone on for 3 weeks. This we will not permit.
My submission.
We will, please understand the position in law. We will go strictly by the position in law. We will give you an opportunity, should Javed Bhatt not wish to continue any further with Ms. Ramakrishnan's petition, no difficulty, we will permit him to de-link himself and we will give him a separate hearing. But he cannot be a part of that petition and say there will be 2 lawyers arguing for them, because there may be a conflict of arguments in that, which is not permissible in a petition. We saw that, for instance, Mr. Dwivedi adopted a different line, but he couldn't do it because he was in a different petition.
And as I submitted, I beg to reiterate, Lord, the situation arose only when Mr. Javed Bhatt came to know that Mr. Raja Ramachandran is not arguing the matter.
But that was so for the last 3 weeks.
Yes.
Everybody knew that he is not going to be appearing for the last 3 weeks. He didn't appear.
Was not appearing in the list.
Well, on the first hearing 2 years ago, he opened the argument. 3 of us were party to the bench. He is the one who had opened the argument. Now it was said thereafter that for whatever reason, Mr. Sibbal now started it. He was not available. Now suddenly in the last date of hearing, at the last nth minute, you say, not only at the nth minute you interrupt and say, well, I want to sail in some other boat.
She's not able to submission. Please, otherwise.
All right, we'll cut through all this. Above all, we are absolutely sure in our mind that we want to give an opportunity to different perspectives, because we have to be duly apprised on all sides, different perspectives, different points of view. As we said, even within the petitioners, there were different shades of constitutional argument. We'll not shut anybody out. We will hear, but let's follow the correct procedure in law. Let's not set down procedures which are wrong. Mr. Attorney General, we'd like your assistance on this. Forget now that you are. Will that be a proper procedure, Mr. Attorney? Yes, Mr. Ramprasad.
all this happened to me. Pigeon. If I may just, I don't know who to.
I gave only purpose of thinking of something.
Mr. Beg, please rest assured, we'll hear you, no difficulty at all. Be in the court, Mr. Beg. Mr. Beg, you can be in the court. You don't have to leave. You can be in the court now. We'll hear you after. You can be in the court. Yes. Please ask one of the juniors to give a chair to Mr. Beg so that he can sit down. Yes. Yes, Ms. Ramkrishnan.
But I'll try to make my arguments in bullet points, so I'm quick. The first point I wish to make is that integration is neither a linear concept nor a quantitative concept. There is a spoken and unspoken assumption that Article 370 is temporary in anticipation of some greater
It's
integration,
neither a linear concept.
nor a quantitative one. My friends on the other side,
Yes. Looks like we'll go on to the lunch. Since we are 6 or 7 minutes short of 4 o'clock, and there's an event at the bar in the evening, otherwise we could have continued till 5:30. You are going to argue on Article 356.
no, I was going to argue on integration, shared sovereignty, and the political context in which this happened, because it's directly relevant to our judging it.
Let me suggest one thing. Can you put down what you really have to so that it brings clarity to us? We are also at the end of the argument, so there's a tendency to be just jaded by the length of submissions. If you can put everything down on one page, just formulate exactly what you're, and then, for every submission, you can cover yourself in about 2 minutes so that we have some clarity on what you're arguing.
That's what I have in mind, but would
fair
you
enough.
want it in writing?
Just a page or so. Just give us a page. No, give it to us tomorrow morning. A page.
Tomorrow morning.
Now, Dr. Guruswamy, on delimitation, we are not going to hear this because delimitation is not an issue at all which arises here.
It was challenged and it is confirmed by this honorable court.
Justice Paul's judgment, yes.
My Lord Justice calls it.
On internal sovereignty.
Sovereignty, not repeating any argument.
And not on delimitation.
That's
Likewise. So what we'll do is, we'll likewise request you to formulate your points on just a page on internal sovereignty, right? Then Mr. Manish Tiwari, what would you be arguing? You are going to Northeast, how can we hear it in this matter?
Follow to abrogate 370 and bring about the reorganization of Jammu and Kashmir and its implications qua the Northeast, because 370 is succeeded by 371 and there are asymmetric guarantees which were given, and those guarantees have implications on national security because the Constitution, while being a legal political document, also performs a very important national security function in terms of integrating the periphery and the
So
revenue.
let us formulate it like this. What you want to really argue is that the impact of the argument which would be propounded by the other side on other similar provisions of the Constitution.
What Your Lordship,
Similar provision.
respectfully, what I want to submit is that there is already a process which has been adopted by Parliament in terms of abrogating 370. So therefore, there's a precedent in place. And that precedent has implications qua the other guarantees in the Constitution, especially with regard to the northeastern state. So those are the implications which I would like to point out, and I would not take more than 15 minutes of your time. And I assure you, it would not be a waste.
Likewise, what we would suggest is if you can put it down on this evening on a one page.
I would do that.
Then we'll have clarity on exactly what the focus is. All right. Then what about Ms. Farasat?
Malice in law, it's a point for anyone. And in fact, one proposition is has been asking, clarifying, and a quick point on federalism.
All right, Ms. Farasat, you can also reduce what you have to say on a piece of paper, on a page.
Yes, I'll do that.
And where's the nodal council? The evening, please put together all this and give soft copies to the court master, what we are now proposing to do. Then what about Mr. Irfan Lone?
Yes, Lordship.
You are for the intervener?
Very briefly, I will not.
You are on federalism.
Federalism, rule of law, and
Fair enough.
democracy.
Fair enough.
Because that is the soul of the Constitution.
Absolutely, no difficulty.
It is not followed in
Just the modalities. Put it down on a sheet of paper so that we'll have clarity on what you're arguing. Because now we have had arguments before you, so we'll know exactly what is it that is different that you are arguing.
This Lordship, we are given only 10 minutes, so within.
Dr. Z.A. Bhatt. Now, malice in law is being argued by Varisha Farasat also.
researcher in 370, there is something very important things which have been left out.
All right, one page, you can please put it down on paper on a page this evening and give it to the nodal council. We'll hear you for 5 minutes or so. And finally, Mr. Gopal Shankanarayan.
Your lordships, candidly.
Now, what we'll do is this. We'll come back to you.
Yes.
Mr. Ramakrishnan, we'll give you 10 minutes tomorrow to formulate. Dr. Guruswamy will give you exactly 10 minutes to formulate tomorrow. Mr. Tiwari will give you 10 minutes too, once you put it down on paper. If you can all circulate it to the court master by 8 o'clock this evening, we'll all have an opportunity to read what you have written by early morning tomorrow. And then everybody else, after Mr. Tiwari, Varisha Farasat, Irfan Lone, and Z.A. Bhatt, we'll give you 5 minutes each to conclude your submissions once you put it down on paper. Then the cutoff is lunch.
Lordship. Lordship.
Mr. Shankar Narayan, after they have all concluded, we'll give you the wrap-up word on the.
Lordship, the earlier list indicates the 10 minutes. So.
You know, time is over already this evening. We have already permitted. So Gopal, be ready tomorrow. We will hear you, Mr. Beg, if you can give us likewise, say by 8 o'clock today, a note not exceeding 2 pages on what your line of submissions is. Please have the note circulated to the nodal council, who is just to your right here, next to Ms. Ramakrishnan, so that that note will be circulated to all the members of the bench by tonight. But do put down what you have to say on a note in 2 pages. And we will hear you right before Mr. Gopal Shankar Narayan. So now the order will be, Ms. Ramakrishnan is in session of the proceedings now. Thereafter, Dr. Guruswamy, Mr. Manish Tiwari, Ms. Farasat, Mr. Lone, Mr. Z.A. Bhatt, then Mr. Muzaffar Hussain Beg, and then Mr. Shankar Narayan. Do you want to hear Mr. Beg before Asina? So much before we rise for the first session, I think we'll be through with this site tomorrow morning. What did you say?
Hey, are you someone who faces problems in remembering Excel formulas? What if I tell you that from today onwards, you don't need to remember any Excel formula? And this is
जी देखिए अब ठीक है। हेलो। हाँ इससे जी इसमें